Demonstrators are no longer on the Ada County Courthouse lawn, but they are not going away. The state of Idaho filed a lawsuit against them last month for violating state code and creating a public health risk. The state ultimately dismissed its lawsuit, but our Andrew Bartline learned the legal battle is not over. Today, demonstrators responded by filing a new lawsuit against the state.
Yeah, well, this new lawsuit argues that several unconstitutional amendments, are regulated in this demonstration. Now, including the right to assemble, the right to demonstrate, protection against unreasonable search and seizure, and protection against cruel and unusual punishment.
From January till the end of March, demonstrators outside the old Ada County Courthouse brought attention to the lack of affordable housing and low-barrier shelter in Boise.
Nobody says they have to agree with their message, but it's a valid message.
According to Idaho State Code, demonstrating on this property is protected as a First Amendment right. However, camping is not protected as a form of symbolic speech. Idaho legal aid attorney Howard Beladoff represents the demonstrators and is challenging the state statute.
Because they don't have a bed to go home to. They don't have an apartment to go home to. They have to go somewhere.
Beladoff filed a lawsuit against the state. He says criminalizing these people for camping effectively criminalizes the status of being homeless.
They're not allowed to have a sleeping bag under the statute, right? But they need a sleeping bag because they have no place to live, right? You make that illegal? How do you make that illegal? That's practically making them illegal.
A 2019 court case, Martin versus the city of Boise, established this is a violation of the 8th Amendment, a cruel and unusual punishment.
And that's what this case is about. You just don't get to treat people in the manner in which these people were treated.
Idaho State Police regulated the demonstration by removing items identified in state code to be reflective of camping. State code says ISP can take unattended property on Capitol grounds and hold it for 90 days before throwing the items away. Beladoff says his client's property was not unattended in the first place, and when ISP took it, none of his clients received receipts for the items or how to get the items back.
So they violated their own statute, in my opinion, anyway.
The Attorney General's office tells KTVB they will not comment on pending litigation. However, Governor Brad Little said in a press release, Idaho does not tolerate illegal public encampments and destruction of public property. Idaho is not San Francisco, Portland, or Seattle, where public officials have engaged in failed experiments to permit and encourage unsafe and destructive public camping.
The only way they're treated as equal in the eyes of the defendants is that they prove their case in court, which they will do.
Now, to be very clear, the Martin versus City of Boise ruling is only relevant if there are no available shelter beds, where homeless people really do have nowhere else to go. The lawsuit is asking to prohibit the state from enforcing the camping statute on their demonstrations. And moreover, Morgan, they want the seized property to be returned and some monetary compensation.
Well, it's important for people to remember, Andrew, that court battle really set a precedent for several states around Idaho, not just the city of Boise.
Yeah, I mean, it's a precedent that's being cited in other states and other courts, and it happened right here in the city of Boise. Kind of ironic that it's coming up again, but now on state property.
Yeah, and unsurprising, too. All right, Andrew Bartline, thank you.